Denaturalization. This is a topic that I've received several questions on recently from clients and prospective clients. So I wanted to take a minute to talk about it. Welcome to Live at Lunch. My name is Emily Sumner with Sumner Immigration Law. I'm so glad that you are joining us, whether you're joining us live or catching the replay. If you have questions about this particular topic, the potential of denaturalization or any other immigration related question, feel free to put those in the comments. I will respond if I can. I cannot answer legal questions, can't give legal advice in this forum. So let's talk about denaturalization. Unfortunately, denaturalization has become a hot topic recently with the Trump administration's recent memo to the Department of Justice, to the Civil Division Enforcement. They in other words, published a memo about civil enforcement priorities, and denaturalization was included on that particular list. So it has kind of bubbled up to the top of the news surface recently. And I think that's why I've had several questions from clients about it recently, which is a valid question. It's something definitely that we should be thinking about and be concerned about. So what is denaturalization? As the name implies, it is the process of removing citizenship, of denaturalizing, making a person who is currently a US citizen no longer a US citizen. That is a process that is permitted. It has been permitted for a while under the current statute. It is rare. It historically has been very rare and only has been implemented in extreme situations like genocide and espionage. To give you an idea of how rare this has been, one source says that, from reliable source, but a source nonetheless, I can't, no guarantees here. But one source says that from the year 1990 to the year 2017, there were 305 denaturalization cases that were pursued. That doesn't mean they were successful. That doesn't mean that 305 people were denaturalized. It means that many cases were pursued. So that's an average, I think, of about 11 cases or so per year. So overall, if you think about the number of people in the United States, the amount of foreign nationals, the number of people who are naturalized US citizens, we're not talking about huge numbers here. It has never really come up, knock on wood, in my particular practice. And I'm friends with lots of immigration attorneys, and I haven't heard of that happening to their particular clients as well. So it's been a pretty rare situation. The Trump administration, like I said, in the memo that they published back in June, they said that they are targeting denaturalization, and the memo lists several factors that I'm not going to refer to all of them here, and I am going to refer to my notes because I haven't memorized them. But notably, remember, when I'm talking about the potential grounds for denaturalization in the Trump memo, they are vague and they are not grounded in the statute. We'll take a look in just a minute about what the statute says, what the law says, and what the Constitution says. So some of the reasons are some of the people that the Trump administration supposedly is prioritizing for potential denaturalization include any citizen that a Department of Justice determines to be sufficiently important to pursue. That's very vague. Cases against individuals that the Department of Justice deems a potential danger to national security, citizens who further or furthered the unlawful enterprise of criminal gangs, citizens who engaged in various forms of financial fraud against the US or against corporations, citizens who acquired naturalization through government corruption, citizens referred in connection with pending criminal charges. So, like I said, that's not every single ground that the memo lists for denaturalization, but the important point here is that there are several different potential grounds listed in the memo, and perhaps more importantly, that those grounds are not grounded, no pun intended, they're not based on the language that is in the statute. So, like I said, denaturalization is a legal concept. It has existed for a while in the immigration statute. And there are two sections, I think, of the statute that are not, I think, there are two statutes that I think are relevant to this particular topic. The first section of the statute, meaning the set of immigration laws that refers to denaturalization, is, if you're interested in looking at it, it's USC section 1451. That talks about when citizenship can be revoked. So one thing that's important to keep in mind, we're going to talk about what the statute says as the reasons, potential reasons, or some of them, that citizenship could be revoked under the law. One other thing to keep that's important to keep in mind is that this is a really complicated process. One of the reasons it's so complicated is because the 14th Amendment of the US Constitution, which is, if you've studied for the naturalization exam, the supreme law of the land, you would know that. But anyway, 14th Amendment to the Constitution guarantees citizenship cannot be taken away without due process. That means that there are certain procedures that the courts have to follow in order to go through this denaturalization process with a person. So typically, like I said, the process is complicated. I have not been directly involved in the process, thankfully, knock on wood. But generally, it involves USCIS recommending that a person be denaturalized or revoking the citizenship of a person be revoked. And then the Department of Justice filing a civil complaint in the federal court. The other thing that's important to keep in mind is the standard of evidence in federal court. So there are different standards of evidence. This is a legal concept, but you may have heard of preponderance of the evidence, preponderance of the evidence, which is generally the standard of evidence in immigration filing. So if you file an immigration benefit, like an H-1B or for a green card, something like that, usually the standard of evidence is preponderance of the evidence anyway. In this particular case, the standard of evidence is higher. There's a much higher bar. The government, not the person being denaturalized, but the government for the person who's being pursued for denaturalization, but the government has to show clear, unequivocal, and convincing evidence that leaves no doubt. So it's a higher standard of evidence under the law, which is not always being followed right now, but that's under the law. So, like I said, the reasons under the statute that the Department of Justice could pursue revoking citizenship of a particular person is if they, quote, illegally procured, and again, I'm looking at notes here, the benefit based on willful misrepresentation or concealment of a material fact. That to me makes sense. You know, if you obtained your an immigration benefit based on fraud or misrepresentation, it makes sense that they can go back and potentially look into that. Becomes a member of or affiliated with subversive, communist, or anarchist government organizations within 5 years of naturalization, received citizenship because of a relationship with a parent and spouse whose citizenship was revoked, was criminally convicted of naturalization fraud, sounds pretty serious, acquired citizenship through military service and was dishonorably discharged, refused under specific or specified circumstances to testify before a congressional committee on alleged subversive activities. So as I said at the beginning, when I first started talking about this, it's rare, it historically has been rare, and it's in extreme situations. If you look at this list that's in the statute, it's pretty extreme grounds. It's not grounds like a person has a pending criminal charge, or the Department of Justice finds the person to be sufficiently important to pursue, or the matter to be sufficiently important to pursue. So you have the contrast of the very vague language and not based in law language under the memo, Department of Justice memo, or the memo to the Department of Justice that's come out versus the law. Pretty interesting. The other thing to keep in mind is that there is a separate, you may have heard of Trump saying that he's, quote, looking into denaturalizing, I don't know the exact word that he used, but denaturalizing Rosie O'Donnell. That actually comes under a different section of the statute, which allows a person basically a US citizen to renounce their citizenship. And there's a section of that particular law that's under, if you're interested, 8 USC section 1481. Under that particular section, a person the government can strip a person of their citizenship, or they can be expatriated if the person commits treason against the United States, naturalizes in a foreign state, or declares allegiance to a foreign state after the age of 18, works for a foreign government, enters the armed forces of a foreign government if the citizen is an officer or the country is engaged in hostilities against the United States. One thing that's important, and that's not, the full statute there, but those are the basic reasons that a person can be stripped of citizenship, which is different from being denaturalized, but stripped of citizenship or expatriated. I can't remember what I was saying, but those are the potential reasons that one thing to note about that is really that section of the law is about how a person can themselves renounce US citizenship. So that is a thing that's possible to do. And it's possible that if a person does one of these activities or takes one of these actions that is I just talked about, or potentially other actions listed in the statute, that even if they don't intend to renounce citizenship by taking on one of those activities, it is possible that the government could see that they did that and then pursue, say proactively to the person, we think that you are eligible, if you will, to be stripped of citizenship or expatriated. But again, there has to be a legal process that is gone through. The government can't just see, oh, you, for example, joined this military and you're an officer, or we're in a war against you, and so you've renounced your citizenship and we're done. There's a legal process that you have to go through. So my point is that within the confines of the law, and this is what I want people to take away from this, within the confines of the law as it's written, and when I say the law, I mean the statute and the Constitution. Yes, it is possible for a person to be denaturalized. It is possible for the government to potentially strip a person of citizenship, US citizenship, or to expatriate them. However, there are specific reasons outlined in the law that are pretty, in the statute, that are pretty clear. And there is a legal process that has to unfold in order for this to happen. You can't just, the government cannot just pull you off the street and say, I see that you've joined this foreign military, or whatever the reason is, you're no longer a US citizen. There has to be a legal process that you go through. That being said, as you know, we are in different times right now, and the law is not always being followed. So this is a concerning development. To anybody who has questions about this, any clients who have emailed me about this, I share your concern. I do think it's concerning. I don't think that there is and again, this is not legal advice, but just in general, I don't think that there is a concern that every single person who has become a naturalized citizen in the United States is at risk of becoming denaturalized. But I do think I'm concerned overall, just because the language of the memo that was sent to the Department of Justice is not consistent with what is written in the law. So we'll have to see how this unfolds. We'll have additional information on this, of course, as we have additional information to share. We'll have updates available for you all. But for right now, I would say that we need to take a deep breath. Like, definitely, this is something to be concerned about. I'm not mitigating anybody's anxiety about this. This is very concerning for everyone. It should be concerning for everyone, whether you were born in the United States or are a U.S. citizen by naturalization, or whatever it is, birth of a U.S. citizen, parent abroad. Anyway, regardless of how you're a U.S. citizen, it is very concerning. And I think it's something that we should keep an eye on closely and advocate to make sure that the laws are followed and that the rule of law continues to be followed in the United States. But I don't think it's something that we need to, all of us who are naturalized citizens, not including me, but anybody else who's naturalized citizens, needs to immediately panic and come up with a plan. I hope that you have found this information helpful. I know it's not a super fun, happy topic to talk about, but I have had questions about it, so I wanted to get some information out there to you all. I hope you found this helpful. If so, I hope you will share this video with a family member or a friend, and make sure that you subscribe to our channel so you don't miss our next update. Until next time, my name is Emily Sumner with Sumner Immigration Law. We serve clients with family-based and employment-based immigration matters around the United States and around the world. Until next time.